Hello, welcome to today's immigration tidbit. You like my new headphones? I'm outside and there's a lot of traffic, so I want to make sure that you can hear me and that I can hear you. So, have you or someone you have known been put into detention, immigration detention, and you just want to get out? You want to get bond? You want to fight your case? Well, it's doable, but not doable in every single situation. In fact, there is what's called mandatory detention under some cases, and that heavily depends on what you may have been convicted of, whether it's an aggravated felony, whether or not you were transferred immediately from from criminal detention to immigration detention. So there's lots of different factors as to whether or not you fall under mandatory detention. And what that means is that no matter how much the judge may want to give you bond, the judge will not be able to because of mandatory detention. Now, there's always ways to appeal that, and it does go up on a fast track to uh, to the BIA. There's ways of trying to get the bond issued by the district director. There's different methods that can be. Now, let's assume that you are not an aggravated felon and that immigration bond is doable. What happens when you are put into immigration detention is immigration will decide whether or not right then and there that a bond is applicable to you. And many times, if they decide it, they'll give a number that is ridiculously high, that for all intents and purposes, many of you would not be able to pay. They'll give like a $50,000 or $100,000 bond. And so, what happens is when you're in front of the judge, what my office does is we do what's called a bond redetermination hearing. And of course, the reason it's called redetermination is because immigration already decided what the bond will be or that there won't be any bond. So I have found realistically that, if immigration says we'll give you a bond and you have to pay $50,000, I have found that when we go and do a bond redetermination in front of the judge, present all the facts, show what money you have and don't have, that we can realistically get that down to like $5,000. Okay, it depends. There's a wide disparity between what immigration thinks you should have and what the immigration judge thinks you should have. So if you do qualify for bond, you definitely want to do the bond redetermination hearing for two reasons. One, because the judge will likely give a bond redetermination an amount you can actually afford. And two, if you get out, you can fight your case while being free, not behind bars, while you're wondering every single day if that's going to be the day you're going to get out. And eventually what they do is they'll wear you down until you sign the document that says, please depart me, I don't want to fight anymore. And then you have to fight your case from outside for years. So it is doable. It is possible. And even if you think you're an aggravated felon, there's still ways of arguing. So don't give up if you're in detention. Do not sign the paperwork that immigration puts in front of you because they only want to make their lives easier. They're not making your lives easier. If you sign a please depart me paper, that means that you have agreed that they can stick you on a plane, a train, a bus, whatever, and get you out of the United States. And that's that. Okay? At least if you're going to be deported, fight your case so that you have a realistic chance of staying. And getting bond is the initial part of that because, if you're sitting in your family's house or your friend's house watching TV, it's a whole lot better to fight your case when you have your hearings than being 24/7 behind bars, especially the way that they would treat you.